Welcome, I'm Russell Alexander. Today we're going to look at a case where the parents are at odds about whether they reach an agreement or an accord. So we recently wrote about this in a blog titled, "Think You've Reached an Settlement Agreement? Maybe You Didn't." We discussed that separated and divorcing couples reasonably assume that their negotiated settlement agreement comprehensively resolves the various legal issues between them. In this particular case, a couple divorced in 2013. They entered into a separation agreement that included a provision for child support in connection with their 4 university-aged children, all of whom were still deemed children of the marriage, as this is a term defined by the Divorce Act, which essentially means it's a child over the age of majority attending post-secondary education, and there's still legal responsibility for that child. This particular agreement stipulated that the father would pay a specified amount of child support for each child who was still living with the mother, but it also contained a special provision which specifically addressed child support for those children who were attending university elsewhere. It stated if a child attends university away from home, the child support will be payable to, in this case, the mother, only for those months that the child returns to the mother's home. Seems pretty straightforward, right? Apparently not. The parties disagreed about this clause and it applied to 2 of the 4 children who are currently studying out of province. One was aged 20 and pursuing education in the United States, but returned home to the mother's place for parts of some months, even during the academic year. A second child was 19 and just started attending university elsewhere, but returned to the mother's home and her place during school breaks. The sticking point was the phrase, only for those months that the university-aged child returned. The parents could not agree as to the father's support obligation, which was impacted by this provision, when the child returned home, even for only part of a month. Let's just say a week or 2 or holidays, or even on reading week, but not the entire month. The court reviewed the contentious provision in context, which included looking at the terms that solidified the father's support obligation to all the children under the federal child support guidelines, not just those who were over the age of majority and attending university. The court's ruling could have gone either way, but the outcome hinged not merely on the wording of the specific sentence, but also on the overall agreement and the parents' presumed intention in making it. Take a look at our blog to learn more and find out how the court ruled in this particular case. The practical takeaway is this: if you're separating and you're in the course of negotiating a separation agreement, make sure you get the assistance of a lawyer who can help avoid any misunderstanding as the ones we just talked about that may entail a trip to the court to sort things out. Otherwise, what you think you've agreed to may be something different from what you actually signed. If you like this comment, please share it with your friends. If you like this video, please share it with your friends and colleagues. You can leave a comment at the comment box. We'll try to answer everybody's question at the end of each week. There's a bell notification that will show up. You can subscribe to our future YouTube videos. I want to thank you for watching and be safe.